Welcome back to our recent Supreme Court decisions. We're really recent today in that this decision came down April 20th. It's called Ramos versus Louisiana, and it's about an individual who was convicted of second-degree murder and life imprisonment, and the individual brought forth the argument that his trial violated the 6th Amendment and the 14th Amendment. Actually, the 6th and the 14th Amendment, and therefore his trial should be ruled a mistrial and he should go free. This decision was decided by a 5-1-3, which means there was a majority in his favor that actually there was a mistrial. And we're going to discuss this case today and the ramifications for future cases, as well as understanding constitutional law. This decision was put forward by Judge Gorsuch, um, and he ruled with 5 justices, and there was one concurrence by Judge Thomas, which we'll discuss him as well, and the dissent by Justice Alito, and 3 in dissent. So this is a case of the question of incorporation of the 6th Amendment into the 14th Amendment. We've discussed similar cases in where the Bill of Rights, how much of the Bill of Rights should be incorporated in the states under the 14th Amendment. Basically, Ramos claimed that he was innocent for his crime, and it went to the state court, and 10 were persuaded that he actually was guilty, but 2 thought no, there wasn't enough proof to consider the man guilty. And therefore, but according to Louisiana law, you don't need a majority, or actually need a majority, but you don't need unanimity. You don't need a full 12 to decide that a person is guilty. It is long enough that it has 10. Now, he brought forth an issue here because in 48 states at this time, you do need unanimity. So if you have a criminal case, you require that the full court, excuse me, the full jury would rule that that the person is innocent. Before we discuss the case of Ramos, let us look at the amendments of the Constitution. The 6th Amendment states that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. So with regards to speedy and public trials, we're not going to get to that right now. Many criminals would argue, or at least people who are or put on trial would say they aren't too speedy, but that's not for now. A public trial means it has to be in the open. It can't be anybody can come and watch the trial, and it has to be an impartial jury. Usually impartial, number one, means an equally fair and just jury. The question for our discussion today is whether or not unanimity is an integral part of an impartial jury. Is that a definition of the 6th Amendment? Now, we've discussed in the past that the 14th Amendment, which is an amendment which deals with civil rights, specifically that was written after the Civil War, and its purpose was to make sure that freed blacks would be treated as full-fledged citizens and would have all rights as citizens of the United States. And we've discussed on the 14th Amendment the question of incorporation. How much of the Bill of Rights, the first 10 amendments, are incorporated in the 14th Amendment? So let's review what it says in this amendment. It says, all persons born or are naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. So we'll discuss specifically which part of this amendment tells us that the rights of the Bill of Rights are sort of incorporated in the 14th Amendment. Over time, much of the Bill of Rights have been incorporated to the states as well, since they're considered necessary for liberty and life for the individual. Therefore, those amendments have been included. Now, the question that we'll discuss today a little bit, as we've done in the past, is whether or not is it from the first part of the second section, is it from the privileges or immunities, or is it from the second section, which is that of the due process of law? So let us begin with Mr. Ramos. Mr. Ramos claimed he was innocent from committing murder. He went to the courts, and basically in court, he almost got through. He actually convinced 2 of the 12 jurists that he was not guilty, or at least there was not enough evidence to prove that he was guilty, but 10 were persuaded. And in Louisiana, actually, you don't need a unanimous decision by the jury. All that's necessary is that you have actually 10 or obviously 11 that can put someone as guilty. You don't need actually to have 12. The problem is that he brought forward that 48 states and the federal court ruled this as a mistrial. There were only 2 courts, at least at this point, before the decision came down, Louisiana and Oregon, that allowed a non-unanimous jury to rule someone that's guilty. Let us begin discussing Justice Gorsuch's opinion. Now, he gets here, even though Justice Gorsuch is usually viewed as a conservative justice, he was the first Trump appointee. And the fact is that on certain cases, he has ruled with more of the liberal court. This is actually has a little bit of a mixture here, as we'll explain, that the court sort of different opinions here, not really conservative or liberal as we've seen in a few cases, but I think as we've learned that actually nobody is sort of stuck in a certain camp when it comes to certain decisions. The fact is Justice Gorsuch here is, in most of this decision, is agreed with the Justice Ginsburg and Justice Breyer. Justice Kavanaugh and Justice Sotomayor are in agreement here. We'll discuss Justice Kavanaugh's decision as well, his concurrence, as well as Justice Sotomayor. But actually, he has these 5 justices on the whole that rule in favor of Mr. Ramos, in that that this is considered a mistrial. And we're going to discuss now why, in essence, the unanimity, according to the majority, is an integral part of not only the 6th Amendment, but it also should be incorporated fully into the 14th Amendment. Justice Gorsuch gives us some of the history, which is really important here in discussing what happened here in Louisiana. In 1898, a non-unanimous jury was considered valid in Louisiana. Before that, you needed a unanimous jury. And one committee chairman at the time said the purpose of this was to establish white supremacy. The U.S. Senate, a week before, passed a resolution to investigate Louisiana. You have to understand this is really right after Reconstruction, and basically there's been a movement here by some of the southern states, actually I would say overwhelmingly southern states in general, to sort of create sort of a division between whites and blacks in various areas, many of them known as the Jim Crow laws. So what they did was they decided to make a facially race-neutral law that would basically make African-American jurors irrelevant. It would be irrelevant, as Justice Gorsuch points out here, because maybe you'll have 1 or 2 and you won't really have to be concerned with them when it comes to trying many black citizens. With regards to Oregon, Justice Gorsuch points out that the tradition, and basically in the 1930s, Oregon adopted, again, a non-unanimous jury, which is based on the Ku Klux Klan influence that really started building up a second time in the 1920s, late 20s and 30s. The first time the Ku Klux Klan was really just a sort of a guerrilla group that started right after the Civil War, and this group was sort of put down by President Grant, but again, it built itself up later in that time, actually having to do with a movie that was sort of put out about the Civil War, and basically really brought a lot of anger towards blacks. There were riots at the time, and basically it built up sort of the Ku Klux Klan again to show its evil head a second time. The question was that the fact is that even the courts understand that they acknowledge that this history existed. But again, the question is, does it really matter, even if the history existed or not? The question before the court is whether the Sixth Amendment right to a jury is incorporated in the 14th Amendment. Does it require a unanimous verdict to convict a defendant of a serious crime? Because really, if you think about it in theory, impartial could really just mean having a fair and just jury. So many of you have been to court and they'll ask you various questions when you come to court, like, do you know this particular lawyer, or do you know this defendant from beforehand? Or do you have information about the case before you've come here? Or other questions like, are you, in theory, against the death penalty? So if you are, you might be impartial, because if the person is going to have the death penalty and you're in theory just totally against it, then you can be sort of put off the jury, because ultimately you can then have that situation, because if you even have a situation of unanimity, it's not going to help under those circumstances. But the question is whether or not, by definition, does impartial require unanimity? So the Sixth Amendment, what is its meaning? So Justice Gorsuch points out, does impartial jury carries with it some meaning about the content and the requirement of a jury trial? And he says that based upon our history, based upon 400 years of history, that unanimity by definition defines an impartial jury. This is brought forth in common law. Blackstone, writing for the common law of England, says that a truth of an accusation by unanimous suffrage of 12 neighbors, indifferently chosen and superior to all suspicion. This is a definition of what it means to have an impartial jury. And he says a verdict of 11 is no verdict at all. During the time of the Constitution, or during the time of the colonies, 6 states at the beginning specifically required unanimity. Some understood it that it was implied. And on the whole, unanimity was a practice of 400 years with the adoption of the 6th Amendment. And this has been validated by later American legal treaties. And courts have studied this in various cases. 13 cases over 120 years required unanimity. The Sixth Amendment right to jury is fundamental to the American scheme of jurisdiction. And therefore, in agreement, the Sixth Amendment, therefore federal cases in federal court are required to have unanimity. The question here is, does that apply to the states? The court at this point discusses a very important aspect, which will be a major aspect of what we discussed today, and that is stare decisis, is that how much validity do you give to an earlier opinion when perhaps, or a good chance, that it's actually wrong. There's a case called Apodaca versus Oregon, which was a case that took place in 1972, where there were 3 individuals, actually. Apodaca is just one of those individuals, where there was an assault by a deadly weapon, burglary and grand larceny in 3 different cases. And it came down in those situations in Oregon with 11-1, 11-1, 10-2 decision. And in 1972, it came to the Supreme Court, and they asked, well, does the Sixth Amendment apply to the states? Now, as we mentioned, it would have to apply through the 14th Amendment. And in that situation, there were 4 that ruled in dissent. Justice Stewart wrote the dissent at that point, that there should be unanimity. 4 others, written by Justice White, included by Justice Berger, Justice Blackmun, and Justice Rehnquist, that unanimity you have to look, does it serve an important function in contemporary society? So it's very possible that it shouldn't apply to the 14th Amendment. And there was Justice Powell, who wrote a dual-track incorporation opinion, which meant, and this is something we'll also spend some time on, is that it could be that fundamentally the Sixth Amendment could broadly apply to the 14th Amendment, but not in every aspect. So there can be a dual-track incorporation. We can take some aspects of the Bill of Rights, not all aspects, and apply them to the 14th Amendment. So the question of the court here is, how much validity should we give to this particular opinion? Meaning it was an opinion that was given 50 years ago or so, and the question is, do we keep with that opinion or not? In Apodaca, the four justices ruled that 12-2 might be not meaningful. It might just be not much of an improvement. It might not reduce hung juries, and that perhaps might be the case. But however, Justice Gorsuch points out that looking at the racial history and the cost benefits, yes, you might have some hung juries, but it's not a waste. It will help deliberate and would stop some zealous prosecutions as well. The cost benefit is your own analysis of the opinion of Apodaca. It's the American people that we need to be concerned about. The Constitution seeks to ensure children's one of liberty for everyone. The job is to preserve liberty, not balance it away with social statistics. So the majority here takes a strong stance and says, no. The fact is that the Constitution and this requirement, unanimity, has been something that is part of the American tradition, has been part of English tradition, and to say that we're going to do with a cost-benefit analysis with regards to the rights of the Constitution and that of life and liberty, no, we're not going to go that way. And we're going to understand that the fact is that the 6th Amendment has meant what has meant since the time of its writing. Justice Gorsuch, as well as Justice Ginsburg and Justice Breyer, tried to prove that in actuality, the theory of one justice, that of Justice Powell, is not enough to call something stare decisis. And the fact is that they say that we don't even value the opinion of Apodaca because it's based on a false premise. The reality is that 6 justices disagree with this understanding of stare decisis. There is something called the narrowest groundwork, which is really, we're going to discuss further in the dissent, that in actuality the 4 justices in the case of Apodaca who ruled that there's a cost-benefit analysis, as well as Justice Powell with regards to dual track, can cause a stare decisis issue. But the fact is that I just wanted to mention that, but the reality is that they don't value that. I want to discuss more about stare decisis and what that actually means. We're going to discuss a little bit about it when we get to Justice Kavanaugh, when he discusses perhaps a theory of how to look at stare decisis, which means stand by the thing decided and not disturb the calm. So Justice Gorsuch says, when do we look at that? So the first thing is that it's at its weakest when we interpret the Constitution, and therefore if it goes against the Constitution, it's practically impossible to correct it without the courts making that particular decision. So what does the court look at? It looks at the quality of the reasoning. Is it consistent with related decisions? We look at the legal development since the decision and whether or not there's reliance on the decision. So the first thing that the quality of the decision is that the plurality in Apodaca doesn't speak about the significance of the 6th Amendment and the racial issues that were occurring at that time. Number 2, it's been consistent for 120 years of precedent and also we've not accepted the dual track is not accepted. The fact is that we see differences in some level between the 6th and the 14th Amendment. The legal development of Apodaca, that it's an outlier, that the fact is that unanimity has been something that has been accepted throughout, especially in understanding the 6th Amendment. And the reliance issue, no one has harbored expectations of a way of life because of a 10-2 or versus a 12-0 decision. 48 states in the federal court have required unanimity. So the only issue that really is being discussed here is whether the reliance on convicted felons already, and maybe appeals might take place, that still the question is whether or not this can be handled or not. So the reality is that Justice Gorsuch, and we'll discuss the majority opinion here, feels that weighing the issues, that the reliance issues are not as broad, and therefore it is more important for us to follow the Constitution under these circumstances. Now I would like to discuss the concurrence opinion of Justice Sotomayor. She makes a few points which I think are important for any person who thinks about the law with regards to issues that we call stare decisis, functionalist analysis, and her opinion of when do we apply stare decisis. So she disagrees with the three justices, as we mentioned, to say that the Apodaca is not a case of stare decisis, that it should not have been viewed as valid throughout the 50 years. She disagrees with that based on the narrowest decision making, as we'll get further in when we deal with Justice Alito's dissent. She points that a functionalist analysis is not a reason to reject, even though, as we mentioned, that four of the justices had decided to say that sometimes you look at things functionally with regards to even defining various constitutional rights. But she points out a few things. She says that the Sixth Amendment has been recognized as unanimity, as we mentioned, for many, many years, hundreds of years. And she says something which I'd like you to think about, is that stare decisis is at lowest when concerning criminal procedure. When it comes to serious criminal cases, burdens are placed on the states. Stare decisis is best involving property and contractual rights, but not criminal cases worrying about burdening criminal justice system. And I think what she's pointing out is that this case should be relegated to the dustbin of history with its racial issues, as well as we're dealing here with a criminal case. I'd like to just mention, when we talk further about this, that I think this is something valuable, what she's saying, whether or not it's true that we only look at the criminal burden on the individual and we don't look at society's criminal concern. But I do believe that with the racial issue here that she makes a valid point. She takes the point very different than some of the other conservative justices, which you really look towards the Constitution as the place where it's on the lowest, stare decisis falls on the lowest concern. But she points out, obviously from the Constitution as well, that the criminal issue is a valuable issue to look at, and that if there needs to be more burden on the states, let there be more burden on the states. We continue with Justice Kavanaugh's concurrence. Again, Justice Kavanaugh agrees with the majority, but he feels it's necessary to actually teach us how to handle a case of stare decisis. So again, he agrees with most of the opinion, and therefore the majority rules that unanimity is required, but he wants us to understand how to apply stare decisis. And the full statement of stare decisis, sharing with you my Latin, stare decisis et non quate movere, means you stand by the thing decided and not disturb the calm. So what are you actually doing? So you're respecting the wisdom of previous judges, and you keep scale of justice even and steady. And it's not liable to waver with every new judge's opinion. Because what you're actually doing is you're making it consistently with regards to law. And you avoid arbitrary discretion in the courts. And what it does is it permits society to presume bedrock principles are fortified in the law rather than proclamations of individuals. So that's the first thing. So understanding that previous laws keeps consistency so society can work itself without expecting various things to happen that they're not expecting, even though we don't expect certain things also, and we're living through it right now. So the question is, stare decisis doesn't mean overruling erroneous precedents. And there are some of the court's most notable decisions have been overruled. And when does that? I mean, we're all familiar with what's called Brown versus Board of Education, which ruled that separate but equal was unconstitutional, that it was actually dead wrong. The decision in the 1880s or early 1890s by Plessy versus Ferguson, which allowed the Jim Crow laws to go into effect, which said it's perfectly fine for black children to be in different schools than white children because they'll get the same education, or that blacks and whites can be in different parts of the bus. I mean, the whole thing is ridiculous. The fact is that that was where stare decisis was thrown out, and it was totally wrong, and therefore, even when the matter is of quote unquote uh, tremendous ramifications and that the society will change. Now, when do you apply such situations? So when it comes to statutes, which are laws that are put forth by the Congress puts forward a law, and it's actually signed by the president. Uh, those are generally left to Congress because they're the ones who brought the laws in. And even if an interpretation was made wrong by the court, they can easily, they can actually change it themselves. And that's even sometimes when the matters of serious concern. When it comes to constitutional cases, it's actually not as flexible. Since once overruled by, let's say, for example, it's understanding of the Constitution, it's a constitutional issue, you'd have to create a constitutional amendment, and that's extremely difficult and is rare. You would need two-thirds of the House and Senate, and then you would need three-quarters of the legislatures in all the states to put a new amendment into the Constitution. Or, for example, if it's the court themselves who made a mistake in understanding a constitutional issue, or they themselves can easily turn it over, there the courts will have more leeway. So now the question is, what do you have to show? So Justice Kavanaugh says, based upon bringing it all together, he says you must show and above that it was wrongly decided. It has to be serious business. Now, what are the situations? Number one, you have to have a special justification or strong grounds. The decision was grievously or shockingly wrong. Number two, decision caused significant negative jurisprudential or real-world consequences. This really made a major factor. And it unduly upsets the reliance interests. So three things. It has to be grievously wrong. It has real-world consequences. And the question is, how much do we actually rely on this? And how much will this upset the reliance issues? So if you look at this, factor number one is that, what about law? This actually makes sense according to law. And facts 2 and 3 we would say is between man and man. As we say, adam lechaveru. Does it apply from man to man? How much does that apply? So if we look at this 1972 case, number one, it was against the original meaning of the 6th Amendment, which requires unanimity, and therefore it should be incorporated. The negative consequences in this case was it silenced black jurors. It resulted perception of unfairness, non-confidence in the criminal justice system, and it's based on the Jim Crow laws. Now, the question of reliance. Well, there's only 2 states that relied on this decision. And the fact is that even though just those 2, it's not a procedural issue. Now, the question is, maybe you'll have other cases that come up. This is also discussed by the majority. But these cases are hard to bring. And there is not substantial reliance in this situation. This is more of a procedural issue. It's not a substantive issue, according to Justice Kavanaugh, and there will not be a lot of cases that will be brought forward. So what Justice Kavanaugh does basically says, under these circumstances, based upon the misunderstanding, the shockingly misunderstanding of this decision and the effects it has on individuals, the reliance issues are not as much of a concern in this case. They don't believe that many cases will come forward. So therefore, Justice Kavanaugh tells us that this case should be thrown out and therefore rules with the majority. We can continue with Justice Thomas's opinion, which is again only concurring in judgment. And let me explain what Justice Thomas does in the circumstances. He rules that a felony conviction by a non-unanimous jury was unconstitutional. But he in no way wants to put his name with the majority because he feels the reasoning of the majority is incorrect and that he is trying to build an opinion. Where does this right the Bill of Rights, when it's incorporated in the 14th Amendment, which part of the Constitution does it come from? He has generally said, and has continually said in his opinions, that the right comes from the Privileges or Immunities Clause, not from the Due Process Clause. And he basically says that liberty is only by a unanimous verdict. So we will discuss Justice Thomas a little bit further, but first, he points out that with regards to unanimity, I'm going to discuss that issue first. 5 on the court in the Apodaca case required unanimity for the understanding of the 6th Amendment, 4 in dissent, and Justice Powell. Stare decisis can't go against the Constitution or duly enacted federal law. They have to be thrown out, and this is a constitutional issue. Our precedents are not out of the realm of a permissible interpretation of unanimity. Since there is a lot of information, it's not the only way to understand impartial jury, but there is a lot of information. Courts have understood it this way, and the fact is that unanimity is a valid interpretation of impartial jury, and therefore it's a valid interpretation. As he says, trial by jury is trial by that body. To almost extent, you might even understand this the way Justice Thomas is, that if you don't have a full majority, it's not a jury. I'm sorry, if you don't have a unanimity, it's not a jury. If you don't have all 12, it's almost like you're lacking something in your own body. It's almost like you're not there. So therefore, this prior interpretation is not demonstrably erroneous, and it's a valid 6th Amendment interpretation. However, he says it applies to states through the Privileges and Immunities Clause. Justice Thomas rules against understanding that it's Due Process Clause that interprets incorporation. This has many ramifications, and he points out that this majority opinion didn't even say it specifically. It could be that Justice Gorsuch's opinion agrees with him, that if you rule by the Privileges and Immunities Clause, it's only those specific rights that are in the Bill of Rights. So, for example, a right to abortion, which is not specifically in the Constitution, or a right to gay marriage, or many other cases that are not specific, they are left to the states to decide, according to Justice Thomas, not to the federal government. And therefore, if you say privileges and immunities, it's only these. But if you say due process, it can include a broader sense, even though I'd say the majority opinion is not following Justice Thomas with the history of the court at this time. Let me mention also that he says something which I'll close with. Close enough is for horseshoes and hand grenades, not constitutional interpretations. And therefore, he's at least happy with the idea that they didn't specifically, I wouldn't say happy, he specifically said it doesn't apply. We don't know what the court has ruled here with how it is incorporated. And therefore, he says that this has been good law, and in the sense that unanimity is a valid interpretation of the 6th Amendment. However, he only concurs with the court because of it being based on privileges and immunities and not due process. We're going to now deal with the dissent. Justice Alito, Justice Roberts, and Justice Kagan. As I mentioned to you earlier, people think that somehow justices are conservative, liberal. Depends where they are in certain cases. Sometimes that inclination could lead them in a certain way. But we find here we have Justice Alito and Justice Roberts, who are generally viewed as more of the conservative, Justice Kagan, a more liberal. Here they all come together in dissent and basically rule that it is not considered a mistrial, and Louisiana's conviction should stand. The reason for this, they say, is first of all, they said that the court gives a rough treatment of stare decisis with little regard with reliance of the decision. For example, nearly 50 years, this is considered good law, and Louisiana and Oregon have ruled in that particular way. Now, the issue of racism pointed out by the majority, the fact is, as Justice Alito says, that when you're dealing with a constitutional issue, you shouldn't really be you should be looking at the constitutional issue. There can be racial ramifications, but the question of the Constitution here, is unanimity something that is required on a constitutional level? So, for example, Louisiana in 1974, as well as Oregon, later revisions were made, in essence, to which were like perhaps there were less racial tensions at that particular time. We looked at it, and racism was not brought up. We find that many other places, for example, in Britain, in Puerto Rico, and other places where they allow courts to not have a jury trial not to be unanimous, and we don't find the racial tensions that perhaps existed in the South in those particular places. Um, Justice Alito points out, as I mentioned, there were only 3 justices who thought that, for example, that it wasn't even precedent. He said that's ridiculous, that Apodaca was not a phantom precedent, that it defies belief to say that. And actually, most justices agreed with Justice Alito on that. It was precedent that later courts relied on. And the fact is that the way we work stare decisis is that we do spend time sort of trying to narrow the grounds. And sometimes it could happen that it could be based on one particular judge. In this situation, it is Justice Powell. And the fact is that he discusses a little bit more about Apodaca and that Justice White's opinion, basically saying that he knew about the Sixth Amendment. He discussed it in previous opinions about 6 months earlier. So there's no need to re-discuss this issue. And so therefore, that doesn't mean that it's a question of an issue of, since he didn't discuss it, that somehow we didn't discuss the Sixth Amendment at all. Not all aspects of the common law do apply. So even though English law might be the case and might be the place where much of the American law was taught from, but the fact is it's not the case. And the fact is that a functionalist analysis couldn't be considered and discussed with regards to issues. And this is also pointed out by Justice Sotomayor as well. This issue of the functionalist analysis was an issue which I wrote about when I was in law school. I wrote about Chief Justice Berger, who was appointed by President Nixon to create a much more stronger criminal justice system through the courts. He was very concerned about the crime that was being committed in the 1960s. That's a whole nother agenda and a whole nother discussion about the racial tensions and other issues that were occurring during the 1960s. And basically, the court in the 1970s really looked towards a more practical and functional legacy of the court with regards to issues like search and seizures and of the Fourth Amendment. And, for example, when the police sort of made a mistake, but in reality, the information would have been valid anyway. This was majorly something that was discussed during the 1970s. Apodaca is one example of Justice White writing. There are many other examples of this, where the court actually in the 1970s more on social issues went more liberal. There was the time of Roe v. Wade and other issues that came forward, which really followed, if people are familiar with the Warren Court. But the justice system got actually pretty strong with regards to some of the criminal issues. And the thing was that Justice White wrote that the right of jury trial is not undermined by allowing a verdict of 11-1 or 10-2. And what Justice Alito points, even though I might not agree with that, but it's too harsh to say it's sort of out of the picture. And for example, Justice Powell as well, that he distinguished between the federal understanding of the Constitution and it being sort of incorporated. The whole thing just happened in 1968, where there was a case called Duncan versus Louisiana, which, if you follow this case, again, a racial situation where there were some white boys who were sort of starting with two black individuals, and then a cousin came by and actually tried to defend them, and then these white individuals basically said, you know, he hit one of us, and then there was a judge who ruled that this individual, Duncan, should go to jail for 60 days. But however, since it was a possibility of having a 2-year sentence, they ruled it a mistrial. It went to the courts, and the court said that the Sixth Amendment, since a person could be in trial for more than can be in prison, for more than a year, then in actuality the federal you require a jury, and therefore was thrown out. So that just came up in 1968. And the fact is, this concept of incorporation we find by other amendments is not fully incorporated. So, for example, Powell's distinction at this time, we've already had 4 justices in 2010 who ruled that the Second Amendment, the right to carry arms, uh, should apply differently for the states and the federal government. That was ruled by 4. That was put forward by 4 justices. Or, for example, even now we have an exception to the Bill of Rights applying to the Fourth Amendment for the states, and that is the Fifth Amendment, the grand jury clause. 28 states have allowed us to have a judge make a decision not to have a grand jury to prosecute. And the court has not viewed that as unconstitutional with regards to applying it to the 14th Amendment. We might see it. I don't know, but at this point, we don't see it. We just included a recent case, as you all remember, the case of, I think it's Timms versus Indiana, with the excessive clause issue of that using the person's SUV that's worth $15,000 for a few drug offenses of $1,000, that was viewed as excessive. And that was just put in last year, for example. And as we mentioned, the Second Amendment as well was just ruled in 2010. And another point is that we don't apply every single issue to juries. There are still 5 states that allow 6-person juries that are unanimous. And the fact is that the common law required 12. So we see that we don't have everything that sort of is put exactly into the Constitution from the 14th Amendment. The last point here is the question of review. And he says this is a serious problem. There's been massive reliance on these situations. Now, it's true that probably 11-1 or a 10-2 would have gone to unanimity if deliberations would have went forward, but the plight of the convicted is not enough. Otherwise, stare decisis could never apply in criminal cases. And this is sort of a line to Justice Sotomayor to say that, well, stare decisis we shouldn't really be concerned about when it comes to individual people who might have committed a crime. So how should we feel about this case, at least my opinion, about how the court is ruled in this situation? The reality is that I think the court made the right decision. Racist charges, especially with dealing with the 14th Amendment and its purpose, this is actually pointed out by one of the lawyers in oral argument, is really what it's all about. The fact is that the 14th Amendment's purpose were written for freed African Americans. And the fact is that the history showing that in essence, the history of racial tension that existed, and specifically writing in this law to exclude blacks from the court, actually defies the 14th Amendment. And therefore, it's clear to me that it should be incorporated. The whole concept of incorporation, which was really put forward by Justice Black, who basically said by definition, the 14th Amendment includes all the Bill of Rights. The court has moved in this direction. Justice Black, who was appointed by FDR in, I believe it was 1939, actually history, very fascinating history about him. He was a senator. There was big issues because he was a member of the KKK. He was still put on the court. Discussed a history about that. But in essence, he really moved with his understanding of the Bill of Rights, that in essence, all parts of the Bill of Rights should be incorporated in the 14th Amendment. That is the justice. That is the whole concept of the 14th Amendment. And we've seen that, especially when it comes to fundamental rights, the courts have moved in that direction. And we find this with regards to many of the criminal situations and gun rights as well, that they have incorporated them into the 14th Amendment. The issue put forward by the Berger Court that a functionalist view of the criminal, I think it still needs to be discussed. I think there are situations where applying some functional analysis, which is also pointed out by Justice Sotomayor, that it is valuable. And you have to really work with that. I don't think it's a blanket thing that all criminal cases that you don't look at the functionalist issue with regards to seeing if it works or not. For example, this is discussed more in depth with the Fourth Amendment with search and seizures. Under those circumstances, applying totally blanket Fourth Amendment without a functionalist issue could cause a lot of problems. Let me mention also about Justice Sotomayor. I think she's brought up some idea which is valuable, but I do think it's questionable whether you should say that stare decisis should not apply to the individual uh, criminal system. They also have to be. They also have to look at the value of the we'd say the cloud, the general society. And many times you have to be pretty strong on some criminal issues. But I thought that she brought something very valuable. That when it comes to criminal cases, do you apply stare decisis? You don't apply it as much. It's almost an understanding of less quality. It is weaker when it comes to issues of criminal. Justice Thomas makes 2 points I'd like to share. Number one is that stare decisis, earlier opinions, have less validity when it comes to the interpretation of the Constitution. And I think that's valuable. I think that's an important point to think about when you understand the Constitution and decisions by the court. That the court, he said this in other opinions, for example, when they looked more at common law as sort of what has more power, well, with the writing of the Constitution, that sort of takes the lead even over common law. So that's Justice Thomas's approach. He also points out, and this is something that Justice Thomas is trying to push, whether or not it's actually going to come forward or not. And this is where I would say, if you would follow the tension between placing various justices on the court and their level of interpretation, this is one area which I think there's a clear divide in the conservative and liberal understanding of the Constitution. Is the 14th Amendment limited to what it says in the Bill of Rights? And if that's the case, anything that's not in the Bill of Rights will be left to the states? Or is the 14th Amendment much broader than that, and that due process is not only an issue of what we call due process of law procedure, that basically all the procedures that are applied to me apply to you when I go to court, but there are concepts of liberty based on due process, which is called substantive, that there are things that are life, liberty, or property that apply that are not specific to the Constitution, and therefore things, as I mentioned earlier, like abortion or gay rights, or gay marriage, I should say, are not part of the Constitution, and therefore can be protected by the states as well. We'll see where that goes. Justice Kavanaugh shares with us, giving us some working ground. Sort of all law professors might be happy to follow through this, and using how to understand the grounds of stare decisis. You look at the law, you look at the effects it has on individuals. As we mentioned, shockingly wrong, real-world consequences, and how it relies on the issue of reliance. So I do believe the majority gets it right here. I think unanimity for a jury is a clear understanding of the 6th Amendment. It should be incorporated in the 14th Amendment. I will say that the issue of reliance is something we need to still look at. Criminal prosecutions are still important, and they need to rely on various procedures. We do find under certain circumstances that those procedures are held back. And what we actually do is we tell criminal systems to make changes, and sometimes those changes are painful. I thank you all for listening. I enjoyed spending time with you. The best to you all.